It's my pleasure to introduce the scholar who's going to present the 15th Annual Saskatchewan Law Review Lecture today, Dean Donna Greschner from the University of Victoria, Faculty of Law. Dean Greschner joined the University of Victoria Faculty of Law in 2008 after teaching for several years comparative constitutional law in California. In this centennial year for the college, having Dean Greschner also allows us to showcase one of our academic stars. Dean Greschner is a graduate of this college, and after studying at Oxford, she returned to teach here from 82 to 2003, receiving the Master Teaching Award for the university in 2002. I can testify to the excellence of that teaching. Was a student. I took every class I possibly could for Professor Greschner. And I was also lucky to have her as my graduate supervisor. Dean Greschner is also the faculty editor of the Saskatchewan Law Review for 5 years. Dean Greschner is a leading national scholar in the areas of constitutional law with a particular emphasis on equality rights, also healthcare law, and legal theory. From 92 to 96, Dean Greschner served as Chief Commissioner to the Saskatchewan Human Rights Commission. She's also been a much sought-after advisor to governments and nonprofit organizations and First Nations groups. Dean Greschner was a member of the Government of Saskatchewan's negotiating team for the Charlottetown Accord in 1992, and a consultant to the Royal Commission on Aboriginal Peoples and the Royal Commission on the Future of Health Law in Canada. Internationally, Dean Greschner has also been involved in advising the African National Congress on constitutional issues, and she's been a consultant on anti-discrimination policies for the Commission on Labor Cooperation. Dean Greschner launches an exciting week here at the college, which will culminate in the Future of Law conference at the end of the week, presenting the 2012 Law Review lecture titled Arguments for Lawyers, The Sleep of Reason Produces Monsters. Please join me in welcoming Dean Donna Greschner.
Thank you, Mark. As I said last night, I'm so pleased to see that the fact that Mark took classes for me has not hurt his distinguished career or harmed him. It's a real honor for me to be here back at the University of Saskatchewan. Some of my very happiest memories were spent here as a student and then as a professor. The law school gave me a lot, and I'm just delighted that it has thrived and that I can give back this tiny little bit. I'm also really pleased. Sorry, excuse me. Is this on? Do you have it? Is it on? I can't forget my obligations to technology. Okay, now we're on. Okay. It's also a real privilege for me to be back to give the Saskatchewan Law Review lecture. For 5 years, as Mark said, I had the good fortune to be the faculty editor of the Law Review, and those were some of my most enjoyable and most educational moments of being a professor, to learn from the terrifically talented students who were on the editorial board each year. So thank you for giving me this honor. Now, isn't it, as I was flying in, I thought, isn't it a testament to the vision of the founders of the province that 100 years ago they decided to create a university that included a law school? I mean, think of the vision. It was one of the very few provinces that had a law school at that time. They had foresight in making that decision all those years ago that certainly has borne fruit. And I think that we owe them our thanks for that vision. I think as I look around the room, I will assume that almost everybody here is either a lawyer or a law student. And the law school has played a really critical part in the history of the province, particularly, of course, in its laws throughout the many decades. Saskatchewan's been a leader, an innovator in all sorts of different areas of laws, and the law school has not had an insignificant role in that. I see here Professor Ron Cumming, who is the architect of modern secure transactions law. He had the genesis of those great ideas here in Saskatchewan and exported them to around the world. Another professor who I had the honor of studying from was Professor Ken Norman, who was, of course, instrumental in designing modern human rights legislation, and I could go on. The law school's been an inextricable part of the legal history of this province, and that is a formidable and quite rare accomplishment for Canadian law schools. And I think that this deserves celebration, as the law school is indeed celebrating. I think it also deserves our thanks and congratulations. So I want you to turn to the person sitting next to you and say, congratulations and thank you, because all of you, whether you're students or professors, you play a part. Now this weekend, you will be treated to an important conference about the future of the legal profession. There will be many distinguished speakers that will give you much food for thought, and I regret very much that I can't attend that conference. As a prelude, however, to those critical discussions, I want to spend my time here today taking us back to some basics. In my view, debates about the future of the legal profession, which is what the conference on the weekend is focused on, need to keep in mind some vital cornerstones. Now, I want your help in this. Okay? I want us to begin a conversation that will continue on the weekend about what the future of the profession, and hence the future of legal education, because we are the gateway. We, being law schools, are the gateway to the profession. What it should look like 20 years from now and 50 years from now. So I need your help. So if you have a piece of paper or an iPad, take it out. If you don't, then use that old-fashioned method of your memory. And ask yourself this question. If you could instruct this law school to teach one course 25 years from now, what would it be? What's the most critical course you want the law school to teach? Okay, I'm going to give you a minute. I'm serious. You can talk to your neighbors. Collaboration's usually better. Okay, so now you have that, you have your one sort of course in mind. We're going to begin with the fundamentals, and let's begin with the fundamental purpose of law, which is the reasonable regulation of human conduct. The reasonable regulation of human conduct. And law is the discipline of reason, and lawyers are its artisans. Now, lawyers do two things as the artisans for the discipline of reasons, and we do really only two things. We help people resolve disputes peacefully. Peacefully. So lawyers negotiate, mediate, conciliate, and sometimes, once in a blue moon these days, we litigate. People have problems. They get into arguments with each other. They get into fights, and lawyers help them resolve those disputes in a peaceful manner. Second, lawyers help people achieve their dreams. Whether those dreams are to form a charity, a corporation, sell their vegan muffins in a Broadway cafe, write a will, make a deal, form contracts, get a divorce. Those dreams are fulfilled with the aid of lawyers. Now, lawyers deal with complicated problems. We are complex problem solvers. Easy problems don't need the assistance of the artisans of the discipline of reason. And all of this happens within a matrix, of course, of a legal system, of the rules and principles and structures that allow people to live together peacefully and plan their activities. All of this, of course, is first-year legal theory. It's first-year legal theory. But we need to be reminded of this, in part and in large part because the business of lawyering is changing dramatically. The business of lawyering barely looks like it looked even 5 years ago or 10 years ago, particularly if you go to larger centers. If you're in a small town in northern Saskatchewan, and I have a particular place of fondness for small towns in northern Saskatchewan, since I hail from one, the business of lawyering may not look very different if you can still find a lawyer, which tells you something about the business of lawyering. But in larger centers, it looks, for the most part, quite different. And this is due primarily to two forces, technology and globalization. And you will hear a lot about these forces in the conference on the weekend. And I just want to give you a couple of examples of how these forces are changing the practice of law. Technology. Technology has democratized access to legal information. And this has been quite a profound revolution. Finding the law was, even when I was a law student, which wasn't quite the dinosaur age, the preserve of lawyers with keys to libraries that were full of musty old books. And one needed a set of practices and skills in order to just find out what the law was. That's no longer the case. Everyone now has access to the statutes and the regulations and all of the myriad of legal rules that govern our lives. All you have to do is Google it. And for the most part, what the citizenry has discovered is that for the most part, the rules need very little interpretation. Anybody can Google, for instance, the requirements of a valid will and download the forms and fill them out. Anyone with a little bit of effort can figure out what it takes to do a conveyance or what it takes to have a divorce, a simple divorce. Of course, if there's custody involved, that's another issue. Okay? But for the most part, the rules are not subject to protracted debate as to their meaning. Okay? Now, we sometimes forget just how, we as lawyers, sometimes forget just how easy it is, this vast mountain of law, and how not subject to interpretation it is. Because, of course, we, particularly law professors and law students, are accustomed to just reading the hard cases that get litigated in appellate courts, where there is indeed reasonable disagreement about what the rules mean and what the right outcome should be. And we then mistakenly think that most law is judge-made law, and the appellate opinion is the paradigm of the legal universe when nothing could be further from the truth. This is what's called a selection effect, a bias based on an unrepresentative sample or selection of the larger universe. It's like thinking that all the universe is comprised of Betelgeuse. Betelgeuse is the biggest thing you'll ever see, by the way. It's the star that's 900 times bigger than the sun. So when you take a look at it in the night sky, you're looking at the largest thing you'll ever see. We're just so far away, it looks like a little red dot. If you just focus on Betelgeuse, you don't realize that most of the universe is empty. And the metaphor here, to continue it, is that we look at judicial opinions, we think they're the Betelgeuse, whereas in effect, the universe is full of statutes that do not need much sweat to interpret and to interpret properly. The legal universe is all about statutes and legislation. And with the democratization of legal information, with the ready availability of this vast mountain and morass of laws, what lawyers then get paid for must change, because no one's prepared to pay for it anymore if you can just Google it. Now, that's, in the most simplistic form, part of what's happening to the profession of law. Now, this, of course, does not obviate the need for lawyers, because lawyers, as I've said, as first-year legal theory tells you, are complicated, are solvers of complicated problems. Complicated problems. So we can't expect to be paid for what have become simple problems. This is, of course, also a historical phenomenon. Over time, what a previous age thought of as complex problems have become easy problems, and lawyers don't get engaged in them anymore. Actually, a recent example was given to me when I was in Calgary a few months ago, meeting with a group of senior lawyers, and for some reason, joint ventures came up. And they said to me that 30 years ago, when they started practicing on joint ventures, the negotiation and drafting of joint venture agreements was for the oil and gas industry was always done by teams of lawyers, and they'd work on all the problems, all the issues, draft this complicated document. Now, because almost every eventuality has been thought of, all the terms have been worked out, all the consequences have been anticipated, lawyers almost never get involved. It's all done by staff. So something has gone from a new problem that rules have to be designed to deal with to something that's mundane and ordinary, no longer complicated, because it's been commoditized or broken into bits or problems have been worked out, whatever has happened to it, and lawyers are no longer involved. And what I think we are seeing, in part because of technological change, is that this pace of change has accelerated dramatically because of technology. But it's the same phenomenon that the legal profession has always experienced. So this then takes us back to the basics. Okay, so if the profession is changing dramatically, how it makes money, what it will be doing, what then are the basics? And this takes us back inevitably to the rule of law. The rule of law is contrasted. What is it that we as lawyers have to keep dear in our hearts? Even when what's in our pocketbook might be changing, or how it gets there might change. And the place to start is the rule of law. Now we can contrast that first to the rule of law to typically what you'll see in your casebooks as the rule of men, or now women too, or the rule of kings, the rule of dictators. The rule of law expresses a wariness of individual judgment, a reluctance to rely on the unguided judgments and whims of a particular person or a particular group of people. It is the foil against arbitrary decision-making based for no good reason. The mocking way of saying this is to say, you know, it protects you from decisions based on what somebody ate for breakfast, or in an example that came up last night at the wonderful dinner that the Law Review editors hosted for me, it would have could have, it didn't do in that particular case, someone like Idi Amin getting up one morning and saying that in a dream he'd been told that all the Southeast Asians had to be kicked out of Uganda. Okay, that sort of arbitrary power. The rule of law says that might does not make right. It's rules that have been announced in advance that stand on some type of solid foundation that must justify the exercise of power. So it tells us that those who exercise power have to point to a rule or an authority for that exercise. Now, first-year legal history will tell you that this grew out of came about by the development of the great writ of habeas corpus. Habeas corpus, as you know, means deliver up the body. And it was developed hundreds and hundreds of years ago to prevent the king and the king's minions from throwing people in jail and letting them languish there. So that if the king's minions picked somebody up and threw them into the dungeon, the person's friends or family could run to a judge and ask for a writ of habeas corpus. The judge could issue the writ. The writ would say, deliver up the body. The jailers had to deliver up the body, hopefully still alive, of course. Deliver up the body, and the judge would ask for the reasons for the imprisonment. The reasons for the imprisonment. What is your authority for imprisoning this person? Now, of course, I'm painting this all very simplistically, but that's the core of the idea of habeas corpus. Okay, and a reason had to be given that was acceptable to the judge. Were they reasons that we would consider sufficient in modern times? Almost certainly not. But it was a start. It was at least the writ of habeas corpus required somebody to tell another person why they were exercising power in a particular way. A modern manifestation of the importance of the rule of law is, where we see it exercised now, or violations of it, are in things like Idi Amin's Uganda, for instance, military dictatorships, and governments that declare states of emergency. In a state of emergency, which many constitutions contemplate, the ordinary rules of procedure are suspended. And that, of course, includes the writ of habeas corpus. And what does that mean? Well, the point of that was driven home to me very forcefully, even though I always had thought of myself as a studious keener who understood all of this when I was in law school. But it was really only driven home to me about 10 years after I graduated, when I went to South Africa. In 1991, Mandela had just been released a few months before that. And I had the good fortune of meeting a person who was a trade union activist. And at a very young age, he had been banned for his work in supporting the black miners in the area around Johannesburg. And banning was a particularly pernicious form of house arrest. If you were banned, you had to stay within your home. You could not write more than 500 words a month. You could not visit more than one person at a time for more than a few minutes per month. You were completely cut off from the outside world. In other words, you were under complete arrest within your own home. And there would be unexpected sort of searches of your home to make sure you weren't writing, you weren't keeping a journal, you weren't having company, etc. So he had been banned at the age of 17 for 5 years. And he told me about this with some bitterness, that the banning order had prevented him from engaging in all of those sort of things that young adults like to do, like date and go to university and things people do between the ages of 17 and 23. So I said to him, was this the worst that you suffered under the apartheid era? And he said, oh no. He said, it was nothing compared to this had happened in the 70s, was nothing compared to the state of emergency in the 80s. Because when the government declared the state of emergency, he said, one never knew when your door in the middle of the night would burst open and you'd be taken away. One never knew in the mornings which of your friends would have disappeared throughout the night and whose bodies would be found in the ditches, killed for, quote, resisting arrest. There was no recourse to any legal means for any of the people who were picked up and imprisoned during the time for the state of emergency. He said that was far worse. The fear, the uncertainty, the arbitrariness of the state of emergency. So that drove home to me the importance of it. I think I had the luxury beforehand of living in a country which, by and large, respected the rule of law, and therefore one didn't have to think about the consequences of what happens when it's not there. And first-year law students, of course, see the articulation of the rule of law in a case like Ron Kuraly versus Duplessis, where Ron Kuraly, a judge tells Duplessis, the Premier of Quebec, that even he needs valid authority by which to strip Ron Kuraly of his liquor license. He can't just do it because he wants to, for some political motivation. So the first core feature of the rule of law is to protect you from whim, from the changing unpredictability that comes from sort of absolute power. The second contrast it's important to make with the rule of law is as a foil against the dictates of faith. Faith is that absolute, unshakable acceptance of propositions that you refute, that either cannot be tested and subjected to critique, or that you will not allow to be subjected and tested by critique and argument. Sometimes these propositions are religious ones. Sometimes they are prejudices. Sometimes they are ideologies. What sets them apart is that the person or the group holding them is absolutely unshakable in their conviction. In spite of evidence to the contrary, in spite of compelling argument to the contrary, that certainty is held to with a fastness that has sometimes horrible consequences. Now, in medieval England, the good example of this were the ecclesiastical courts. Okay, so, and religious courts that typically throw up some good examples of how the presuppositions and assumptions that are grounded in certainties that are not allowed to be challenged can produce horrors. Now, by contrast, to go back to my point, law is the discipline of reason. It questions the exercise of power. It questions the assumptions on which power is based. It insists on justifications. It asks, where is your evidence? What is your evidence? What are your reasons? Are your reasons sound? Show me your arguments, not just your assertion of power or your assertion of certainty. And this, I think, is well represented by Goya's famous print, "The sleep of reason produces monsters." When your critical facilities go to sleep, what horrors might be dreamt of that are uncontrolled. Now, for you now as lawyers, if this is the basic spark and impulse of the legal system that the legal profession should uphold, what does this mean? Well, this critical role is important, I think, in two things. First, in something like Ron Corelli versus Duplessis, where someone is asked, where's your power, where's your authority for doing X? So is there a law that even applies to this exercise of power? That's a straightforward rule of law problem. It applies every day in criminal courts, for instance, where lawyers say to the prosecution, well, you say this person committed X offense, where's your evidence? Does this person's behavior actually fall under this statute? So every time that decision is made by a prosecutor, by a judge, by a defense attorney, you're comparing evidence to the legal proposition to see if that evidence actually fits what is prohibited by that law. You do this every day. You engage in that form of legal reasoning. I also submit to you that it also applies in designing new statutes or reforming old ones. New statutes, of course, often completely change the nature of the set of rules that govern a particular situation. That's what the PPSA did with secured transactions, for instance. That's what workers' compensation did with respect to tort law for people injured on the job. That's what the Automobile Accident Insurance Act does. A whole host of legislation that first-year students here in the crowd have now become familiar with can completely change the legal landscape. And sometimes old laws are reformed in that way. And new statutes must be subjected to the same requirements of evidence and argument, reasoned argument. Now, we do this, we hope, through the legislative process, where proposals for law reform are put forward and tested and questioned. But it is, I submit, also a mandate of lawyers as professionals to ask those questions as well. What's the evidence for this law? What is the problem that the law seeks to address? Does the proposed solution effectively address the problem, or does it make it worse? Does it miss the mark? Or are there much better solutions available at the same or less cost? Now, with the acquisition of the imposition of the Charter of Rights and Freedoms in 1982, this has also become, of course, absolutely a legal question, because that's what the Charter requires. It doesn't take much thought to come up with a rights violation, and then we ask the question, is this law demonstrably justified? And those are the questions that the court asks in the Oakes test. The same questions that I submit lawyers have always been asking in their role as legislators, as public servants, as engaged citizens. Now, this role of the legal profession is also critically important, and of course reasonable people can disagree on whether or not the evidence, and evidence in this instance will often be a matter of much debate. It's social science evidence. But that, of course, doesn't obviate the core function just because a lot of stuff is vague and has shades of gray. Let me give you a clear example of this, of a law which, if we were in the United States, I would submit it is our duty as lawyers to oppose. There's a law in Texas and a number of other states that requires women seeking abortions to be warned about the danger of breast cancer before they receive an abortion, even though there is not a scintilla of scientific evidence that having an abortion increases the risk of breast cancer. This particular law is based on ideology, or as my friends who are scientists would say, junk science, ideology masked as science, because it's dressed up in scientific language. And it ought then to be condemned and derided by lawyers regardless of your personal views on abortion. Regardless of that. This is a law that doesn't meet some really basic criteria of evidence and sound justification. Now, the next question then is, well, if we're going to insist on the requirements of evidence and sound reasons based on evidence, acknowledging that much evidence is indeed debatable, what is that based on? And here I think one goes back again to the rule of law and its genesis throughout history, and not just British history, and that is the inherent dignity of every individual. Every person, whether pauper or press baron, who would be adversely affected by an exercise of power had the right to say, or to call upon a judge to say, do you have a legitimate authority for that exercise of power? Okay? So everyone should be subject only to laws for which there are sound justifications, legitimate authority. And I know I'm fudging a lot of complicated theoretical questions here to make the basic point, which often gets lost. It often gets lost because, of course, nothing in the rule of law demands substantively just laws. It just demands that there have been a law already articulated that can be defended on something other than personal whim or unshakable certitudes. Now, the legal form for this particular underpinning of the rule of law is now called rights. An individual has a right to call upon and seek justification for the exercise of power against them. You have a right to demand that the power holder show their hand, state what their power is and where it comes from. And it is from this sort of genesis that produced the rule of law hundreds of years ago that also produced our modern notion of human rights, of course, and now quite different and more potent and much more precise forms. Now, Goya again expresses this quite well in a print from his Disasters of War series. This is another series of prints he did, which illustrated the horrors of the French invasion and occupation of Spain from about 1810 to 1820. The entire series, for those of you not familiar with it, is absolutely horrific. There are scenes of brutality and torture that are almost beyond imagination. Now, one print does not show gross torture and brutality. It shows a mother begging for her children. And the caption is, "The worst is to beg." Now, think about this. Why is that the worst? Because Goya, who was a astute social critic, would have said, to put words in his mouth, that a beggar, in legal language, this is my language, a beggar has no rights. A beggar has no entitlement. A beggar doesn't even have anything to exchange in terms of what they need or what they want. So the worst is to beg. Now, what does all of this, so these are the fundamentals. These are the fundamentals of what a legal system needs to have, the fundamentals of what the legal profession ought to uphold. And so what does this mean today? Well, I think for the legal profession, the one point I want to make, because you'll hear all those experts on the weekend, is that the legal profession needs to be independent. There needs to be some protection so that lawyers who argue on behalf of Ron Corrali, who argue on behalf of the stupidity of the law like the one in Texas, are not disbarred or otherwise punished for taking views which are unpopular or against the dictates and whims of the government of the day. So there is core value of the independence of the legal profession, which is inextricably linked to protecting the rule of law. Now, I want to focus a little bit more on the short amount of time I have left on legal education. What does this mean for legal education? So what did you pick? What was your course? I'll try not to look at a former student. Yes, what did you pick?
Just so happened to be peacemaking.
Peacemaking. You would pick a course on peacemaking. That's a wonderful idea. I should write that down. Okay, what did someone else pick? There's no wrong answers. What did you pick? Yes?
Constitutional or legal writing.
Legal writing or constitutional? Very good choices. Yes, legal writing, of course, because the only tools lawyers have are words. So the better you can use words, either speaking or in writing, the better a lawyer you will be. Because part of peacemaking, of course, is good, clear communication. And constitutional law, not just because I'm a constitutional lawyer, but because it's the basic structure of the legal system. Now let's take another one. Over on this side, what did you pick? Yeah.
Practical application of the theory that we learned to the practice. Practical application.
Practical application. So some clinical programs, perhaps. Show me how to use this theory. Okay? That's also a very good idea. Oh, let's have one more. I'm having so much fun. Okay, at the very back of the room. Not you, Donna. Somebody in the back. Do you want to volunteer? Sid, what did you pick?
We picked the rights of old people.
The what? The rights of old
Rights of
people.
old people.
Rights of old people. Okay. Yeah, okay. That's good too. Yes. The rights of elders. The importance of elders. So to just spin on that a little bit, that would be a course on the importance and proper use of tradition. Not just tradition alone, but the proper use of tradition, the experience of the ages as well as the aged. Let me give you a couple of my suggestions. Okay? All of yours are excellent. And other than the rights of old people and maybe constitutional law, which this might be a little different, there's no one substantive area. Did you say secure transactions, Professor? Come here. Legal reasoning takes evidence and applies good reasoning to the evidence. So wouldn't it make sense to have a focus on evidence? On how we know things and how we prove them? And not just evidence in trial processes where it's an individual and we need to decide in a basic criminal trial whether the person has committed the crime or not. And that, just as an aside, I'll give a pitch for the professor who's coming, I think, next week. I saw the poster, Jennifer Chandler, who'll talk about neuroscience. Because neuroscience is telling us an awful lot about how we know things, how our brain knows things. So wouldn't it also make sense to teach and for us to learn about evidence in the broader broader sense, what in constitutional law is sometimes called social science evidence, but what I would call just science evidence, so that we as lawyers have better tools and we're better equipped to deal with the claims of science and the claims of junk science and be able to tell one from the other. Because lawyers, as solvers of complicated problems, are solving problems in areas of science. This is called medical malpractice or builder's liens, construction problems, a whole host. Lawyers will work with experts from every other discipline. This has been going on for a long time. That again is a change that is only accelerating at a phenomenal pace. So wouldn't it make some sense to at least know how to find out about how to assess evidence in these other disciplines? And why isn't evidence then, maybe it is here, a mandatory part of a lawyer's education? That basic ontological question, how do we know things, and how do we know whether things are true or not? How do we assess truth? My second suggestion, these are in no particular order, but there might be an order, you tell me, is public choice theory and practice. Lawyers, I have submitted to you, have an obligation to criticize bad laws and to help design good ones. We, don't have a broad enough scope of our obligation as a professional if we think that our obligation is only to deal with a particular fact pattern involving a particular individual. Not that that's not important, but that's not all that we should do. Well, how do we know whether, if there's a particular problem in society like cyberbullying, what's the best way of dealing with that problem? Let's take a problem like childhood obesity. Doesn't look perhaps like a legal problem, but the solutions, the proposed solutions will all have legal form in one way or another. Most of them will. Okay, what should be the responses to try to alleviate that problem? Should we have regulation of the food industry by putting labels on foods where kids read them? Should we regulate the food that is sold in schools? Right? These are almost every response, and I won't go into detail on this, but almost every response thought of to childhood obesity, to trying to reduce it, has a legal form, of course. Well, how do we assess what sorts of solutions are better than others? And why isn't law school teaching us that when that's such a critical part of our role as professionals? It can't, of course, make us experts on public choice theory. It can't make us economists. It can't make us doctors. It can't make us engineers. But it can at least give us some very basic tools so that we understand and can find out more about the basics of those other areas of expertise. Okay, my third suggestion. Basic logic. You know, the lawyers apply reasoning to evidence. And yet we don't systematically teach reasoning. We expect law students to come into law school with a pretty good grounding in logical reasoning and in reasoning skills, and then we expect you to improve by osmosis as you sit in courses that are taught in a quasi-Socratic method. Why don't we give it sustained attention? Why don't we teach law students how to recognize, for instance, the 10 top fallacies made by judges in opinions? Right? It would help judges too. If they could identify the top 10 mistakes they've made. You can go to any university bookstore in the philosophy department and pick up wonderful books, big thick books, listing all the fallacies. I should have brought one in with me, right? Yet we don't methodically teach students about it. We don't methodically teach law students how to construct good arguments and how to recognize bad ones. We expect you to pick it up by osmosis. And that, I think, is a deficiency that we should think about correcting. Okay? For instance, most legal arguments are, particularly in the hard cases that are litigated, are arguments by analogy. And how many of you, if I gave you a minute, could give me a definition of an argument by analogy, of analogical reasoning? A definition. Any volunteers? Maybe 10% of you? Is that a high number? Okay. use it all the time, and you should know at least the basics of how to construct a good one and how to recognize a bad one. My fourth example is history. Okay, and not just legal history, although legal history is extremely important, but the history of maybe I will say the legal system. Constitutional system is what I want to say, but I don't know if that's biased on my part. And this is, of course, because the life of law is not just logic, it is also experience. It's not just experience as well. Lawyers learn from the past. I mean, this is, of course, built into the notion of the doctrine of precedent. Okay, precedent, we don't follow precedent just because it happened in the past. We follow precedent because we know that precedent has something to teach us. Has something to teach us. And if we're not going to follow precedent, we need a good reason not to. That's the doctrine of precedent. Precedent teaches us, if nothing else, humility. That maybe we don't have all the answers, and that maybe the answer that was given in the past is still a pretty good answer. Let's at least think about it. Let's at least think about it before we dump it. So those are my suggestions offered with some humility. I could be wrong. Okay, this is not, of course, a certainty. I want you to construct arguments as to why I'm wrong. And what you would then put into a curriculum that would assist lawyers, law students become talented, expert lawyers 25 years from now. Now, in closing, and I was told once by a politician that if you say in closing, you can talk for another 25 minutes. Because people think you're winding up. I'm not going to do that, okay? I'm going to talk for just another minute or two. I want to actually go back to last year's Law Review lecture, which Mark very kindly sent me and which I read, and it was given by John Ralston-Saul. And he began his lecture by saying I quote, "The most difficult question to ask in a law school is, what is the value of proof and precedent versus the value of ideas?" I could not disagree more profoundly with this question. I think that reveals a misunderstanding of what law is all about. Law is caught up inextricably with ideas of every single sort. Ideas flood into the law at a pace that even before this change wrought by technology, we had a hard time keeping up with. There's no shortage of ideas that come from every corner, every discipline, every political persuasion. Ideas that seek to regulate human conduct, because that's the business of law. And proof and precedent are not in opposition to the value of ideas. They help us assess which ideas are good ones and which ones are bad ones. The most difficult question, I would reframe this, I would say the most difficult question to answer is, what are the good ideas about human conduct, ideas that exemplify and promote justice, that makes people's lives better, versus the bad ideas? And law gives us the tools to help answer that question. It doesn't give us the only tools, but it gives us some fairly powerful ones. It gives us tools based on history. It gives us tools based on our experience. It gives us tools based on reasons. It tells us, it instructs us to pay attention to what has happened in the past when we're considering a new idea, not to blindly follow the past, but to think maybe there was some good idea back then, and we should pay attention to it. It tells us to apply some critical thinking, to demand evidence, to ask for proof before we seek to revolutionize a particular area. And Goya, again, and I want to end with him, recognized this. He called ideas imagination. And the subtitle to the famous print, "The Sleep of Reason Produces Monsters," is this: Imagination, abandoned by reason, produces impossible monsters. United with her, so reason united with imagination or ideas, she is the mother of the arts. And I would add the mother of justice, too. Thank you.